now, even before it showed up here
Well,
today.
yeah, no problem.
I just don't know if I can offer you, how much you owe, 100 and,
I think the judgment's 120 plus fees.
Plus
So I
fees
think it's about
and interest.
140 maybe total. Yeah, and some, but the interest is pretty low now.
I mean, I really think I can get you something. I think it might not be enough.
Yeah, understood.
But let's talk after,
Yeah. Well, we'll see
after
what
this.
the report.
You talk, you know, we could, you know, ready to roll? I'm ready as I live.
Substantial crowd,
Yes,
cell phones,
yes.
That's why I don't know what time it is. I turn off my cell phone.
Smart move. Change crew and that is the board. Just editing me in, even if you're just emailing me now, she's like, I'm myself. I'm like, really? Because I'm kind of bored back here.
Yeah, if you did 10 hearings at one time, right?
yes, we do. We'll be reading them. All rise. Court of Appeals Division 1 is now in session.
Good morning, thank you. Please be seated. We are here in our cause number CACV 130065 involving GLIC Real Estate Holdings LLC versus Northview Holding LLC et al. This is the time set for oral argument in this matter. Each side will have 20 minutes to argue. Appellant, if you'd like to save time to respond, we will let you manage the clock. And the clocks are on the podium, and you can watch them count down. This is being audio recorded. If we need to listen to this, it's also being video recorded. I think we're going to put this to music later on, put it on YouTube. So if there's something something snazzy you can say to leave for posterity, please do that. We've begun doing video, and I don't know how long we're keeping it, and I suspect we're just trying it out. Maybe we're trying to shame the U.S. Supreme Court into doing it. But whatever it is, we have read the briefs, we've conferenced this matter, we have an understanding, at least as the two of you see it, of the three important documents, the note, the guarantee, and the deed of trust, and what all that means. So with that in mind, Counsel?
Thank you. Good morning, Your Honors. Just briefly, I want to talk about the parties and then talk about the guarantee and the carve-out provision that is the subject of the lawsuit, and then I'll get into the meat of the issues. We've got Northview Holdings, LLC. That is the owner, the borrower, who signed the promissory note. Then we have two guarantors, Town Lake Enterprises, LLC, and then the individual person, Gerald Fanditis, who signed the guarantee of the loan. This is a bit of an unusual situation because this is a non-recourse promissory note, meaning that the lender agrees to look solely to the property for recovery against the borrower. However, there are carve-out provisions. We refer to those sometimes in the industry as bad boy provisions for certain type of behaviors or activities that the borrower does that should lead to liability beyond the non-recourse of the promissory note. And typically you might have an environmental spill, a borrower who steals rents, pockets the rents, doesn't pay the mortgage, lets the property deteriorate and the property's damaged. And here, a provision for property taxes, which Pelley's counsel and myself disagree on exactly what that means. But that is the carve-out provision we are here on today. And I think it's important to look at the guarantee first, and then I'll talk about the carve-out provision. The guarantee signed by Mr. Fanditis and Town Lake Enterprises is a guarantee of the loan. In fact, if you look at the guarantee itself, it uses the word loan with a capital L. Refers back to the loan. The guarantors are guaranteeing the loan to the same extent the borrower is liable. No more, no less. And I know there's part of the arguments that the lender has made here is that the guarantee, they have the right to sue on a guarantee as a separate obligation. Well, that's very, very true. They do. But it's still a guarantee of the loan, and we have to look to the loan documents to define the guarantor's obligation because they're guaranteeing the borrower's obligations under the loan. And I'll talk about more about that in a second. In other words, what I'm saying is if the obligation is not a debt that's due by the borrower under the loan documents, then such obligation is not being guaranteed by the guarantors. I think it's a simple subject, but it's very, very important to keep that in mind. And I've quoted at great length the guarantee in my opening brief. And I won't go into it here, other than I think it's worth pointing out that capital L has very, 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 very substantial importance here as far as how the guarantee should be applied. The carve-out provision.
So are you basically saying that nobody promised anything other than to pay off the loan?
No, not saying that.
They didn't promise to pay off the taxes?
They promised to pay everything the borrower paid, and they promised to pay everything the borrower owes under the borrower's carve-out provisions, which are identical to the guarantor's carve-out provisions. So no, I'm not saying that at all. There are obligations due beyond the obligation of paying back the principal of the loan.
That's what's carved out.
That's what they call the carve-out, exactly. And the carve-out states that under the promissory note, again, identical language in the guarantee, any taxes or assessments relating to the property encumbered by the deed of trust which accrue prior to foreclosure sale under the deed of trust or any transfer of said property in lieu of foreclosure. Those 35 words, that's what we're here for. And I think it's interesting to point out that in those 35 words of this provision, the words, the deed of trust, is mentioned twice. Lender is saying the deed of trust has no application to determining whether or not there's any liability under this carve-out provision. Yet the specific provision they're suing on, the very provision they're suing on, mentions the deed of trust twice in that short little sentence. We have raised 3 defenses.
We know you raised the language from the deed of trust, but doesn't those 35 words just essentially say, we know that there's property encumbered, so if any taxes are on that property that accrue prior to foreclosure, then the carve-out applies without referring to the deed of trust, without referring to the language of the deed of trust.
Well, it doesn't. You're correct. It doesn't refer to the language of the deed of trust. It actually, if we dissect that sentence, it refers to the deed of trust in 2 different manners. First, as Your Honor just indicated, any taxes owed under relating to the property encumbered by the deed of trust. It's a very general reference, and then a more specific reference, which accrue prior to foreclosure sale under the deed of trust. So they're talking about a foreclosure sale under the deed of trust, under this carve-out provision. And that's more significant because the defense, the first defense, or the defense which I want to concentrate on because it's a complete defense as opposed to the other defenses, this particular carve-out provision specifically references taxes which accrue prior to foreclosure sale under the deed of trust. So obviously, it's difficult to get in the intent of these forms, but there's some contemplation here that there's monies being guaranteed here, obligations being guaranteed relating to a foreclosure sale of some sorts. I'm not sure exactly what the intent of this drafter meant, and if I came up here and said I did, I'd be lying. Nobody knows. But it's interesting to point out that definitely references a foreclosure sale under the deed of trust.
Well, it references the timing of the foreclosure sale, but I think I'm hearing you say that it means more than just the timing.
It depends what you mean by timing. If you mean before or after, but the taxes are certainly.
It just simply says taxes which accrue prior to the foreclosure sale under the deed of trust.
Correct.
So that gives us a date.
Of what taxes may be due, yes.
Are you arguing that this language means something more than that?
I'm saying, as far as yes, I'm saying it does imply that the contrary to what the lender's arguing, where they're saying this deed of trust has nothing to do with the carve-out provisions. I'm saying these 3 documents, the promissory note, the deed of trust, and the guarantee, they're all integral. They all have to be considered. They all have to be read together in the context they should be given. That's what I'm saying here, and I'm probably not doing a very good job saying that. But that's all I'm trying to say. The carve-out doesn't define what our defense is relating to Section 8.3 of the deed of trust. It doesn't get into that at all. I'm just pointing out the fact that the deed of trust is mentioned throughout these loan documents. In fact, if you look at the definition of what the guarantors are guaranteeing with a capital L loan, that's the promissory note in the deed of trust, defined by the loan documents themselves. And that is important. The deed of trust, and as I've stated in my briefing, it's a form supplied by the lender. If it's subject to 2 different reasonable interpretations, it should be construed against the lender, and I think that's the case here on both our defenses. And Section 8.3 specifically applies to proceeds at a trustee sale, specifically. And it's titled Application of Sale Proceeds. And it states, the proceeds of any sale under this deed of trust will be applied in the following manner. Will be, I think, means the same as shall be. I don't think anybody would contest that. First, to the payment and expenses of the trustee sale and trustee costs. Second, and this is our defense, payment of all sums expended by lender under the terms of this deed of trust and not yet repaid, together with interest on such sums from date of disbursement at the applicable interest rate under the note from time to time, or the maximum rate permitted by applicable law if that is less. So, and then third, and I think this is important to look what the third one is, payment of all other indebtedness secured by this deed of trust in any order that lender chooses. So the deed of trust form here, supplied by the lender, states the proceeds of a trustee sale. We have a trustee sale, $2.8 million bid by the lender. Those are the trustee sale proceeds.
Well, are there proceeds?
Absolutely, Your Honor. And why should this provision be treated any different, whether the lender bids and applies with a credit bid, applying the sale proceeds, applying its loan amount towards the sale proceeds, or a third-party bidder? Secondly, and I've cited...
Because a third-party bidder is actually going to pay somebody some money.
It's
That might be the answer why.
Your Honor, it is payment. And this provision, 8.3, does not distinguish between a credit bid and a payment by a third party. And then, and I submit to you, and I've briefed this in my opening brief, if you look at the trustee's deed, and it's attached as Exhibit 6 to my opening brief, the trustee's deed very clearly, I don't have it right in front of me, but it talks about the sales proceeds and payment, the word payment being used and proceeds being used in the trustee's deed itself that delivers title to the lender.
I think the provision makes sense if this was a recourse obligation. Because if you prepay sums up front and less go to the indebtedness, then you've got a larger deficiency.
Right.
But that's not
Well,
this scenario.
Potentially. It's not, and the deed of trust is actually a fully recourse deed of trust. I mean, it's written in a way that it doesn't mention that the non-recourse language is put in a provision in the promissory note.
But isn't that what really governs? The deed of trust governs the sale of the land, but the obligations are governed by the promissory note because that's the loan document.
I disagree, Your Honor. You're 90% right. The other,
Hey, if I got 90%, most of my life, I would have done a whole lot better. than
You're
I did.
correct.
Yes, yeah.
The deed of trust does many things. It gives the lender basic rights. Here it gave the lender the right to have a receiver appointed. That's in the deed of trust. The deed of trust provides other protections to the lender. The deed of trust gives the lender the right to do a judicial foreclosure or a non-judicial trustee sale. The deed of trust does a lot of things. The deed of trust also has a provision, by the grace of God for my client, I would assert, that the proceeds of the trustee sale have to be applied in this manner, will be applied. The court can't rewrite this provision. You can interpret it, yes, but you can't rewrite the provision saying, the lender shouldn't have done that. It specifically says the payments of all sums expended by the lender under the terms of the deed of trust not yet repaid, those are advances. Any kind of advances that the lender makes shall, the proceeds of sale have to be applied to that second after the trustee sale cost.
Well,
Then third,
let's apply
any other
that
thing
to
they want.
How does that apply to the taxes? The lender hadn't paid the taxes yet at that point, had they?
They had not, but it doesn't,
So at the moment of foreclosure sale, if they had paid taxes, maybe these, if we had real proceeds, or if somehow these are considered as proceeds, they would be required to go to pay off past payments of taxes that the lender had made, but the lender hadn't made any.
and I know that's what an argument the lender's making, but Your Honor, the section 8.3, and please, it does not make that distinguishment. And here, I could make the same argument that, hey, you can't sue for taxes that you paid after the trustee sale because the loan obligations were then satisfied. That doesn't make sense, and it's the same logic applies here. The lender's suing for monies it expended after the foreclosure.
Are the very specific carve-out provisions.
Right,
I
right.
realize we haven't
Okay,
talked- we haven't talked about what accrue means yet, but look, on this point, I mean, at first I thought I think you were arguing that the three main documents all needed to be considered and interpreted together.
Right.
But doing that, doesn't the other side have a pretty doggone good argument that, hey, this is a sort of a vague, imprecise little provision, 8.3 second, in contrast to the very specific provisions in the carve-outs and the note and the guarantees. Construing them all together would be odd to say that 8.3 defeats the specific intent expressed in the carve-outs.
No, let me tell you why I disagree, Your Honor. The carve-out provision applies. To the extent we can argue what crude means,
Under your
but it
analysis,
applies.
there'd be nothing to
but
carve out.
Because the carve-out provision obligation has been satisfied by the proceeds of the trustee sale. That's the difference. Not because it was never owed to begin with, it was owed. We can argue what was owed, but it was owed. The taxes that were due and payable were certainly owed under the carve-out provision, as of the day of the trustee sale. But
Why is it not, why is what you're arguing not the same as saying that the carve-out didn't carve anything out?
because that would be, first of all, that would be an erroneous legal argument, because the carve-out provision does carve things out. This provision 8.3 only applies to a trustee sale which generates proceeds from the trustee sale that are applied in this order under section 8.3. The lender had a right to do a judicial foreclosure. They wouldn't be bound by this provision. They chose not to. They chose the easier route, and my client would have a right of redemption. They would have loved that. They chose the easier route of using a trustee sale, and they're bound by the deed of trust once they do that. And the 8.3, although it may be vague as far as the carve-out, it's very specific as far as how the proceeds are to be applied. And it has to be controlling because the carve-out doesn't talk about payment, it just says that defines the obligation. Section 8.3 of the deed of trust talks about how the payment's going to be applied, satisfying the carve-out provisions. To the extent this court finds 8.3 is ambiguous as far as timing, before or after the trustee sale, whether the lender pays those funds, I would submit to you the law is very clear in Arizona. If there are two reasonable interpretations of a contract, it's to be construed against the drafter of the contract, which is the lender. And I think it is vague in reference to the timing on that. But certainly it's a reasonable interpretation that these apply to any funds expended by the lender, whether it be before or after the sale.
I just want to make sure I'm following. The vagueness part that you're referencing is the idea that the taxes could be paid later. It's vague on
Yes,
that.
yes,
Is your point.
vague on the when the taxes can be paid. And I submit to you this, and then I'll save the rest for rebuttal. If the lender had, let's say there was excess proceeds, someone came in and bid
$15 million.
$15 million. That's going to make my math more difficult. But there's excess proceeds, and then the lender pays the property taxes after the trustee sale. And the borrower, my client, comes in and says, "We want all the excess proceeds. You're not allowed to take your funds. You can sue us for it, but we get the funds from the trustee sale because those are not monies that you expended under the deed of trust." The lender's going to say, absolutely, under 8.3, we're entitled to those funds. This provision can work against the borrower and in favor of the lender if there were excess proceeds.
It may be that it's a provision intended to apply when there are excess proceeds.
It doesn't say that, but you may be right. I'd like to reserve the rest for rebuttal if I may. Thank you.
Thank you, Your Honors. May it please the court. Isaac Gabriel on behalf of Appellee. Let me just start. I think this is actually a pretty simple matter. I know that we delved into the weeds there a little bit on the deed of trust, but the thing that I want to focus back to is the language of the note and the language of the guarantee. Because what both the note and the guarantee say is that they just don't guarantee unpaid taxes as of the foreclosure date. It says they guarantee any and all claims, demands, damages, losses, liens, etc. And so regardless of when these were paid, if they were paid pre-foreclosure, the day of foreclosure, after foreclosure, the lender has been damaged by the non-payment of the taxes. And what you have is you have that very language covering liens or losses or whatever it is. It's less money going into the lender's pocket, whether it's sold to a third party, whether it's sold at a trustee sale, whether they're taking it back via their credit bid. And so what you have is a very simple provision, a carve-out provision on a non-recourse loan. I agree with everything that counsel said in terms of this loan being non-recourse, no deficiencies other than these specific carve-outs. And these specific carve-outs are set up for that very reason. If lender has to exercise its remedies via foreclosure, or if the borrower just walks away and gives back the property via deed in lieu, which is the other contemplated scenario under the guarantee, you've got to have paid all the taxes as of that date. And that's pretty simple. Otherwise,
The deed of trust contain the carve-out provisions?
The deed of trust does not, but I will point you, and we've always asserted the deed of trust here, this 8.3 does not apply. And I'll say it doesn't apply for two reasons. One is, as Your Honor,
It'd be easier to say it doesn't apply if the deed of trust had the same carve-out provisions.
well, it doesn't need it, because this is the guarantees not, well, let me back up. Deed of trust isn't signed by the guarantors. So the guarantors have a separate independent contract obligation. The guarantors agreed to be on the hook for these amounts, independent of the deed of trust. They said if you are damaged or have a loss,
So they're in a better position than the signer of the note?
well, the signer of the note is in the same position as the guarantors as well. But the guarantors are, I would say, independent. I'd say they're both independent in terms of the distinct obligations. But let me point you to the deed of trust if we do want to look at 8.3 and give you a couple reasons why 8.3 doesn't apply. Number one is it says all sums expended by lender. So as Your Honor mentioned, as of the date of sale, lender had not paid any sums. There was nothing to pay. We simply took the property subject to a priming tax lien. And that is exactly what the guarantee and the note cover. We were damaged. We had a loss. We have a lien. Basically, end of argument as far as I'm concerned. Second, though, is if you look at section 8.4, the very next section in the deed of trust, it says waiver of order of sale and marshaling. And it says, lender shall have the right to determine the order in which any and all portions of the secured obligations are satisfied from the proceeds realized upon the exercise of any remedies provided herein. So once you exercise your remedies, the borrower can't force us how to apply this and say, no, you have to apply it first to your attorney's fee, so I'm not on the hook for that on the guarantee, or you have to apply that first to the taxes, or you have to apply that first to whatever.
The 8.4 gives the lender, upon exercising remedies, the right to reject anything in 8.3.
Yeah. I mean, if you read the deed of trust as a whole, and this is how basically all loans are set up, once we're exercising remedies, and once you're in a default, kind of all bets are off. You make a payment.
8.3 relates to the remedy of a foreclosure sale. Right?
I don't know that it does, Your Honor. It says upon the proceeds of any sale.
Any sale.
Yeah, I mean, it says, so to me, that could be a third-party sale. But 8.4 is very clear that you can't force me when I'm exercising my remedies, you cannot force me how to do that. But I don't even think you ever get there because.
Are there any cases that tell us that?
There's shockingly.
Like 8.4 control over provisions like 8.3?
Well, I think you just have to read it together, and if you read the intent of the argument of the document, it seems pretty clear to me. Obviously, I'm the bank's counsel, so I will admit some bias there, but it seems pretty clear to me, and this is how basically my understanding of every loan I've ever worked on works. Once you go into default, you start making payments to me, you don't get to dictate how I apply that. I get to apply it first to my late charges, maybe my interest, maybe default rate interest, maybe the attorney's fees, whatever it is. But generally, all your loan documents will say, once you're in default, I get to determine the order of payment. I could apply it first to principal. That would benefit you most. It would burn down the interest that's accruing faster. But the deed of trust, in our view, doesn't apply for, really three reasons. We have a separate and independent note obligation and guarantee obligations. You have separate contractual obligations that cover losses, damages, or liens. Second is, under 8.3, you have all sums expended by lender as of the date of sale. Well, there weren't any. We just took subject to a lien. So you can't extinguish sums that have been expended when they haven't been expended.
So that provision just means that the lender would have had to pay, made a demand, and it hadn't been repaid.
I think so. I mean, I still would argue 8.3 doesn't apply in the first instance, but yes, I mean, I think that's the only way you could get there. And I still don't think that would defeat the independent 8.4 or the independent obligation that says, hey, we guaranteed your damages, we guaranteed your liens, we guaranteed your losses as a result of any accrued and unpaid taxes. So to me, okay, let's just say it was extinguished. I mean, let's just go with that assumption. Let's say, okay, that extinguishes it under the deed of trust, it went and paid that. You still have a loss. We still have a lender who suffered a loss and damages as a result of the unpaid tax lien on the property. So even if you say that it extinguished it, I don't see how that defeats the guarantee obligation. The same way that if I say I'm going to guarantee, your third-party obligation to somebody else, and if somebody else pays that off, I mean, generally, somebody's going to be able to step into the shoes and argue a guarantee obligation here. So we still have a loss, no matter how you slice it, because of this priming lien. So in our view, the reading of the documents is pretty simple and pretty straightforward, and that was the whole point of these non-recourse loans, was
hey, we're not going to sue you on a deficiency. We'll just take back the property, provided that you pay the taxes, you pay the insurance, you don't run off with the rents, you don't let waste happen to the property. A pretty simple bargain for exchange. And for the most part, I mean, this borrower got off on, or there would have been a deficiency of probably around $1 million that they're not paying because of the way this loan was structured. So under a plain reading, in our view, it's pretty simple. If you want to, I know we didn't touch on this really in the main argument, but then that takes you sort of to the accrue provision. And what does accrue mean? Again, accrue, these are loan documents. These are sophisticated parties. This is pretty simple stuff. Accrue, like let's just take interest. Interest accrues on a daily basis and then gets paid on your payment date. So your interest accrues, you make a principal and interest payment, interest is gone, principal gets burned down. Next month, same thing happens. Interest accrues, et cetera, et cetera. Taxes are the same way. Taxes accrue. They accrue on January 1 as of the assessed tax rate, whatever it is. They get paid or become delinquent at certain dates. You pay the second half of taxes on, I think it's March 1 to May 1. You pay the first half of taxes from October 1 to November 1 to pay them timely. And this is how every real estate transaction works. If you sell your home in the middle of the year, let's say in July, technically your first half of 2013 taxes aren't due yet. But the buyer doesn't step in and assume those liabilities. The buyer doesn't step in and be like, oh yeah, I'm on the hook for all that now. It's your title company pulls that off, takes that aside, and then they start with their accrual of taxes from the date that they become the owner. So this isn't complicated stuff. And the note uses the term accrue differently for interest accrual. There was no confusion there versus due. And just the general word accrue, obviously, in our view, means, the plain language is, it means the amounts that have accrued as of the foreclosure date. There's no dispute as to the 2010 taxes. Those were accrued and past due. It's the stub period from January 1, 2011 or 2012, I don't remember the year, but to the foreclosure date of September 26th. And that's the amount that lender had to pay. That's the amount that lender was damaged by. So in our view, the accrue argument is also very simple. The last, I think, kind of argument really goes to the mitigation of damages argument. And what the other side has said is, well, the lender should have done more. The lender should have somehow, leased up the property or generated some revenue in some sort. And so what we have to look at is, well, what were the undisputed facts and what's the undisputed record in this case? The undisputed facts are the tenant, the borrower, lost their tenant, Ultimate Electronics. They filed bankruptcy. The property, which was a single tenant building, became vacant. It basically became a big box shell at that moment. And that triggered the default because there was no rents coming in for the owner to pay the bank. And the bank put a receiver in place via the Superior Court. The receiver, basically that is the mitigation of damages that the bank has done. The receiver comes in, takes over the property, makes sure insurance is kept, makes sure the property isn't vandalized, makes sure that whatever landscaping is there is being maintained, and make sure the property doesn't deteriorate or go into any waste.
If the bank had wanted to lease or rent part of the building or the whole building during that time frame, could the bank have worked with the receiver to get that done?
Well, the bank, let me answer that in a couple parts. You have to remember that the banks get in very precarious situations here, and this is why you get a receiver. A receiver is a third party who is appointed by the court, who answers to the court, and who has to post a bond to basically secure his conduct.
How much bond here, for example?
I don't remember. I think it was probably in the $100,000 range, somewhere around there. But the reason you do that is because if you're a bank and you go in and take over a property, and let's say you make a bank officer the manager and just kind of kick the tenant out, you're now a mortgagee in possession. You don't own the property as a bank until you foreclose it. So you have no rights of ownership. The bank doesn't have the right to lease the property. We don't own it. The borrower still could have filed bankruptcy all the way up to the foreclosure date. And if we were owning the property and trying to lease it out and doing things, then they could say, well, we have damages. You sent it out to a tenant who was not creditworthy and damaged the property, or you released it in a not in the best and highest use. So banks aren't in the business of taking back properties and leasing them out before they foreclose it. A bank does. They put a receiver in, They protect the property, they foreclose it, now they own it. Now, once they own it, they can do whatever they want. They can hold it, they can lease it, they can improve it, they can sell it.
What sort of title or rights does the receiver have during this period?
The receiver had broad powers under the receivership order. And the receiver, if he thought it was worthwhile and feasible, could have tried to lease the property, or could have tried to sell it, or could have tried to do whatever he wanted. He can force place insurance, he can do whatever he deems necessary. The problem, of course, is this is a vacant building. There's no rents. There's no revenues coming in. So how can the receiver release the property? He can't pay a broker commission. He can't make tenant improvements. He can't do anything to improve the property unless the lender is going to advance out of pocket some substantial sum of money to make that happen.
As a practical matter, isn't the receiver generally answering to and doing the bidding of the lender?
Well, he can't. I mean, he can't just do the bidding of the lender. The lender can certainly say, you know what, we're not going to advance $500,000 for tenant improvements in the next 3 months. The lender's not obligated to do that, and if the receiver has no money, he can't go out and lease the property. But if the lender says, hey, receiver, I want you to, tear the roof off or put a new roof on, and we're not going to pay for it, and he's going to be like, well, how am I supposed to do that? He still has his independent judgment.
But if the lender says, I want you to do A, B, and C, and I'm going to fund it.
If he thinks he can do it, it's possible. But that's the whole point. Mitigation of damages doesn't say you have to take these extraordinary steps. This particular building, actually, once it was foreclosed and sold and went out to a third party, someone did come in and buy it and sink a few $1 million into it and ultimately sell it. But that's not what the bank has to do. The bank is in a very limited, tight spot here, and the bank is not in the business of being a real estate developer. The bank is in a business of foreclosing.
I think you've got pretty good facts on your side on this issue, but why isn't there a question of fact?
Well, because you can't just say you didn't mitigate your damages. You can't just say you had to do more.
Well, they came in and said people are making inquiries, people are asking about leasing it. Someone offered to lease it for $23,000. I forget what the record says. $23,000 a month. Or?
Right, and we filed a motion to strike on that issue, and the court, at least at the hearing, it wasn't in her minute entry, but the court in the transcript more or less agreed with that and said, I think that these are all hearsay statements, because what you had a former owner claiming that he had been told by someone else what they were willing to do with the property.
Were they the former owner?
The former, I guess, operator, because the receiver had dispossessed them of the operations. So what wasn't attached was anything that would overcome the hearsay exception. So there was no, maybe if there was, let's say, a letter of intent, and he had received that and said, hey, I got this potential tenant here. Here's my letter of intent. This is a business record. It falls under the business record exception. I'll show that to you.
How is that really any different than if somebody comes and says to the former operator, I would rent this for $23,000 a month?
Yeah, well, if he'd submitted a declaration from somebody who said that, that'd be one thing. He didn't submit a declaration from anybody. There was not a shred of admissible evidence.
Submitted his own declaration.
Correct, which was all hearsay. So there was.
You think it's hearsay if somebody in a contracting situation, for example, says, I hereby offer to sell you 2 widgets for $10? Is that hearsay?
Hearsay to prove to whom? If you're a party.
To prove that an offer was made?
Well, if you're a party, that's different. If you're a party to my dispute, that'd be an admission by a party. If then I took that and then went to somebody else and said, hey, I could have sold my house for $1 million, and it's like, well, where's the proof of that? That just you saying that doesn't make it true. If you're using it for some other purpose, and that's what they were doing. So there's no.
So Judge Flores thought all of this was hearsay.
Well, if you look at our motion to strike, we moved to strike basically the allegations of what was allegedly what he could have released the property for, because it was all based on just his statements his statements, which were from other people's statements. So somebody else.
Without any detail.
There was some detail, but there was nothing that would overcome the hearsay exception. There was no, for example, one was Sears. Sears wanted to come in and lease this property. One, that was never communicated to the receiver, if that's true. There was no declaration from the receiver saying, hey, I looked at this, and yeah, Sears would have come in, but the bank didn't let me. There's no declaration from Sears saying we were serious about that, and we would have done it. So it's just a guy standing up there saying, oh, I had 10 tenants. Well, where are they? Like, I mean, it's just hearsay statements that aren't backed up by anything, and they don't overcome any exception. They don't fit within any exception in the hearsay rule. So the normal way that it would work is, I think, if you wanted to overcome hearsay, is you'd say, here's the letter of intent. I received this in the ordinary course of my business. It was, received by someone who has personal knowledge of it, and you lay down the foundation of 803, 4, 5, whichever the business exceptions is, and you get that letter of intent in through that exception. But just to say it is not evidence.
Although
It's
I'm
not
not
admissible
sure,
evidence.
I'm not sure about what the business records exception in this application that you're giving us would just resolve one level of hearsay. It's still an out-of-court statement.
Oh, yeah.
If every statement is hearsay, but my point is not every statement is hearsay.
Not every statement is, but certainly a statement of, I will lease your building for $23,000 a month on a month-to-month lease is a statement from another person offered for the truth of the matter, that someone actually would have done that. And that's hearsay unless you've got that person to stand in court and say that, or unless that statement fits into some exception. And there's no exception that it fits into. The only one I can think of possibly is if it had been in writing and if you have a business records exception. So this notion of, hey, I could have leased it at, by the way, the very bottom of the real estate market, when attached to our affiance statement of facts and our affiance affidavit, is all the letters from the other side telling us how dismal this is, how much money has to be put into this property to lease
That
it.
may not help their case very much.
Yeah, I mean,
on
it's,
that score.
you have statements from the party agent basically saying, you should take this really discounted payoff because it's impossible to lease this, and if you take it back, you're going to be worse off.
Is there a location that you happen to recall in the transcript before Judge Flores where she talks about your motion to strike?
I don't have.
Okay, we'll find it.
I believe it came up at the early part, and she said, I believe she said something to the effect of.
I just was lazy, and if you knew right where it was,
I don't know off the top of my head. I apologize.
No problem.
But so on the mitigation, the real point in our view on the mitigation is a bank is not obligated to go out and try to do a variety of extraordinary acts, particularly when we don't even own the property. We are a bank, and if we did things, we could potentially be sued for lender liability. So you have a third-party receiver for that exact reason, to create distance between who's running and operating the property and who can make independent judgments. And the other key point here is, if they thought the receiver did something wrong, the receiver was discharged. There was no objection to the receiver's discharge or to
Would
his
they have
bond.
needed to raise some of these issues before the receiver was discharged?
Yes, our view is if you have not objected to the receiver's conduct, then you are stopped from challenging that conduct. Because technically, if the receiver does something wrong while he's a receiver, you sue the receiver. You don't go and sue the bank because we weren't in control of the property. The receiver had the exclusive control and domain over the property. So if you said, hey, receiver, you let this tenant walk away, and if you had signed him, it would have been a $5 million property. You had a duty to sue the receiver or object to the receiver's discharge or seek his bond or seek some kind of a hearing. But otherwise, you're basically collaterally stopped from then later saying, no, this other party had some duty.
Does that knock out the entire mitigation of damages argument? Because I'm not sure it does, because I'm sure that the other side will say, well, our complaint wasn't with the receiver. Our complaint was with the lender.
Well, I think you could still have, and I know I'm out of time, but I presume you don't mind me answering.
No. Don't. If we mind, we would have told you.
Okay.
If Judge Porley will allow it, please go ahead.
Let's say, for example, they had said, listen, we can't operate the property, we're abandoning it, we recommend that you put a receiver in. And we said, no, we don't want to go through that cost. And then in the meantime, the property gets stripped of all of its copper and deteriorates and goes down in value. And then we seek a deficiency where we're saying, the property was worth $2 million, now it's worth $1 million because it's been damaged, so we're seeking this full deficiency against you. If I was on the bar side, I'd say, well, wait a second, you had a duty to mitigate damages, you had the right to get a receiver, you could have protected the property, you didn't, we put you on notice, and you didn't mitigate your damages. That's very different from saying, we put a receiver in, we kept insurance in place, we maintained the property, and what you should have done also is spent $1 million and re-tenanted it for whatever purpose at the very bottom of the recession when we just told you it's impossible to do that. That would be an extraordinary step that would impose obligations on a lender well beyond what is in the common law. And it's their burden to prove that we should have done that. They didn't attach any evidence. They didn't attach anything other than some statements, which we said were all hearsay, and which were stricken, and the judge agreed and said there's no admissible evidence showing a mitigation issue.
Thank you.
Thank you, Your Honors.
Your Honor, I'd mentioned at my opening remarks that there was a trustee's deed that contains language about the payment, the bid price being treated as a payment, and I've quoted that on page 18 of my opening brief at the bottom. Block quoted the trustee's deed. I think that's, I won't go into any more, but just want to draw the court's attention to it. It mentions, very clearly states that the bid at the sale is made in payment to the trustee, namely $2.8 million, which payment was made by the satisfaction of the obligations then secured by the deed of trust. So clearly, the trustee's deed states that these proceeds from the credit bid are going to be treated as partial satisfaction of the deed of trust. 1 second on my cruel argument. Counsel mentioned about the usual, someone goes in and buys a house and the property tax is prorated, but that's because the contract in those cases always contains language that's going to be prorated on a per diem basis. We don't have that here.
Isn't that what the word accrue means, though?
I don't know what it means, Your Honor. I mean, it means a lot of different things to different people. I would submit, my only statement I'm going to make on this is submit to you this.
The document uses both the word due in a different context than accrue, so aren't they different words?
But not on taxes, not on property taxes. So they're asking for this court to interpret this, the word accrue, to mean something not yet due and payable, something not yet owed under law. And I just think it's ambiguous, can be construed in two ways. I'll move on. I briefed that as probably as well or as long as I possibly could.
Well, don't necessarily rush. We'll control the clock.
Okay, thank you, Your Honor. On the mitigation issue, and I didn't want to win on just the mitigation issue because I think 8.3 is a complete defense, and I strongly believe we're right on that.
What about 8.4?
Well, 8.4, I don't know what 8.4 means. I mean, it's a vague sentence that says they can apply the proceeds. It doesn't even use the same terminology. It doesn't use proceeds from a trustee sale. 8.3 talks about proceeds from a trustee sale. That's what we have here. 8.4 is proceeds from a sale of a property.
Yeah, I don't know if I can pull it up. I think 8.3 just said sale, but I
8.3? No, 8.4 is very vague. 8.3 says application of sale proceeds. The proceeds of any sale under this deed of trust will be applied in the following manner. A sale under the deed of trust is a trustee sale. That's what we have here. 8.3 is very specific. 8.4 is just a general term. I don't know what it means, but to the extent it conflicts with 8.3, 8.3 has to control because it's specific. And by the way, I've never seen a provision like 8.3 in my entire life. So we talk about normal course of loan documents. I've never seen one like that. I'm not even sure why it's there, but it is, and it's specific, and it has, even if it's a harsh result to the lender, and maybe does something the lender didn't want, that's what it says, and it's controlling in this case. With respect to my mitigation, one quick thing. There are questions of fact all over the place. The affidavit from Mr. Van Dytus was very specific. He got a call from Sears. He mentions that they're
What's your
willing to
best
pay.
argument for why it's not hearsay, though? Why not attach an affidavit from someone from Sears that says we're willing to lease the property for this amount?
Bad counsel. I didn't think it was even remotely hearsay to have an owner who's an owner of the property at that time say, I've received calls from prospective tenants, here's what they're willing to do. Mr. Van Dytus also states they tore my signs down, my leasing signs down. And keep in mind, the receiver was in place immediately after Ultimate Electronics vacated.
How about your best argument as to why any claim isn't waived by not challenging the receiver before the receiver's release?
I don't think we have a cause of action against the receiver at all. I don't think we have a cause of action against the lender at all. The lender has the right to let that property sit vacant under its deed of trust and under the receivership. They have that right to do that. That's their decision. But if they make the decision to let that property sit vacant, there's a question of fact that they failed to mitigate their damages if they're going to sue my client for property taxes accruing during that very same time period where you could have stuck a big, keep in mind, this is a big box, 35,000 square foot building at Arrowhead Mall. It's a nice building. There are people wanting to rent this, even on a short-term basis. And when a receiver comes in, removes my client's signs, takes control, and files a report with the court saying no leasing activity was considered. That's not hearsay. Those are facts, maybe disputed facts, but they're facts that are alleged, not subject to the hearsay rule. And Mr. Fanditas' affidavit contains scores and scores of information that was not hearsay, but first-hand knowledge. Maybe it's disputed. Of course, and maybe it's disputed that's not a failure to mitigate. But those are questions of fact, and the court erred in striking the affidavit, if that's what the court intended, and the court erred in not finding questions of fact on this mitigation issue, which, again, let's look at the timing of this. The property taxes they're suing for are accruing at the very same time period that this property is sitting vacant with a receiver in place, tore my client's signs down, and has filed a report with the court saying, we're not considering any leasing activity. Mr. Fanditas also says in his affidavit he talked to the receiver, he talked to Sears personally. This is not secondhand hearsay information. Thank you.
Thank you very much. We appreciate the argument of counsel.
Judge, I did find the discussion, it's about page 12 to 18 in the transcript.
12 to 18?
Yes.
Okay, thank you.
Appreciate the discussion of counsel. It has been helpful. We will take the matter under advisement and issue our written ruling in due course. Until then, we stand adjourned. Hope everyone has a wonderful holiday season.
Thank you.
Very good job. Very good job. Suppose you don't know what your client would take, but
I don't.
we settled, I don't know if you're aware of this, but I know we had this other lawsuit against us on the Channel Shopping Center, people that took that property over. And we sued Fanditas and might have been two other entities. And we settled that case a few months ago. So,
Okay.
I mean, we paid $15,000.
Yeah, I'll talk to
They-
them. They're a little different because they are a insurance lender, so they're subject to some different
Rules.
regulations and
Yeah.
rules. But I know generally, I would think it would at least take whatever the fees are plus something.
Yeah,
For them to walk it.
I understand.
Marjorie, my client, can be a bulldog
Well,
sometimes.
it's not being a bulldog. I mean, it's business.
Yeah, I mean, yeah, but
And,
some places we don't have that. Some places. Yeah. I'll check it then.
Okay, well, very, very appreciate that. And I know